Jennifer, we're about to go live, okay? Okay. The Senate Committee on Human Services will come to order. It's Monday, February 27th. Welcome back to the beginning of another week of legislative happiness. We have a pretty full agenda today. There are 3 bills and an informational meeting that we're going to start with, and all of these issues really tie together. The focus today really is on child safety, how we can improve child safety in Oregon, especially when we have issues of... Yes, Senator Olson?
I'm just smiling because I think they're focusing on all of your bills.
Well, some of them are committee bills.
Yeah, but they're good bills.
Well, one of them is your bill. You're a chief sponsor on one of these bills, Senator Olson.
Yeah, I know.
All right, so you distracted me.
I did.
So we're going to do the informational hearing first. There's a great deal of material and information in OLIS, so you might check some of that out. You can get to all of it through the meeting materials section for all of the meetings, and there's a lot under differential response. It has a variety of documents from DHS. There are also a variety of human services scholarly articles and kind of historical information about implementation in Oregon and in other states of differential response and impact on child safety. We also have, and we'll do this really quickly, introduction of committee measures. Almost all of these are simply placeholder bills that have relating clauses that if we get to April and we're stuck on something, they give us the space to do that. So pretty much all of these bills don't say a lot. And remember that a vote for introduction is not a vote on the merits or on the content of a concept, nor does it guarantee the draft will be referred back to this committee, nor that it will be scheduled for a hearing. So I'm going to open up a work session on the introduction of committee measures. Senator Olson.
Madam Chair, if I just may first ask a question. You said pretty much all. Are there any ones in there that are definitely bills?
There is it the last 2? I just have the list here. I think there's 2. There's one that came from Housing Community Services, and it has to do with affordable housing. There's another one that has to do with discipline of employees at DHS.
Oh. Chair Gelser, I move that the following legislative concepts be introduced as committee bills. LC 2641 dated 11/15/16, LC 2645 dated 11/15/16, LC 2937 dated 11/29/16, LC 2938 dated 11/16/16, LC 2940 dated 11/21/16. I wanted to catch him, he was checking them off. LC 2939 dated 11/21/16. LC 3776 dated 2/6/17, LC 3778 dated 1/26/17, LC 3780 dated 2/16/17, LC 3784 dated 2/16/17, LC 3793 dated 2/22/17, LC 2712 dated 12/2/17, LC 3755 dated 2/21/17, and LC 3779 dated 2/6/17.
May I please borrow your paper? Thank you. Vice Chair Olson has moved that the following legislative concepts be introduced as committee bills. LC 2641 dated 11/15/16, LC 2645 dated 11/15/16, LC 2937 dated 11/29/16, LC 2938 dated 11/16/16, LC 2939 dated 11/21/16, LC 2940 dated 11/21/16, LC 3776 dated 2/6/17, LC 3778 dated 1/26/17, LC 3780 dated 2/16/17, LC 3784 dated 2/16/17, LC 3793 dated 2/22/17, LC 2712 dated 12/2/17, LC 3755 dated 2/21/17, and LC 3779 dated 2/6/17. Is there any discussion?
Madam Chair, could you go through that list again to make sure we got them all?
No. But thanks for playing. Is there any further discussion? Is there any objection? Seeing none, so ordered. And to all the people that will see these bills introduced, almost all of them are placeholder bills, so you don't have to panic about analyzing them. They all create task forces. as placeholder bills do. So I'm closing the work session on the possible introduction of committee measures and opening an informational meeting on differential response. So we're going a little bit out of order. We have Jennifer Nash on the phone, who's an attorney from Benton County, who needs to move on to her other responsibilities. So we will bring her up first before the department gives us the overall presentation about differential response, which is a way of kind of serving families when they come to the attention of the department. And with that, I am going to turn it over to you, Jennifer.
Thank you, Senator Gelser. And thank you for the opportunity to provide testimony regarding my concerns regarding differential response. My name is Jennifer Nash. I'm an attorney in Benton County, as Senator Gelser explained. As part of my practice, I represent both children and parents in juvenile court. For 16 years and until June of 2016, I was the administrator of the Benton County Legal Defense Consortium, which is the group of attorneys that provide public defense services in Benton County. I was the administrator during the implementation of differential response in Benton County, and I attended all of the meetings that were hosted by DHS about the differential response rollout in our county and about what differential response was supposed to be. And I'm here to talk about my experience with how differential has actually been implemented or has occurred in Benton County. Differential response was presented to be a helpful resource for families who were low risk and who needed essentially a helping hand through a tough time. In practice, it has not been used in this manner. It may be used some of the time for those families, but it's also been applied and used for families who are moderate or high risk, where the allegations that come into screening don't rise to the level of filing a petition or having it go on the alternative track. So in my experience, it's really the allegations or the concerns that cause an analysis at screening of whether a case goes on the differential response track or the traditional track, not an analysis of the family or the family situation overall. These families who are placed on the differential track are offered services, and in my experience, they have little or no follow-up, and there's little monitoring of children in the home. There's little oversight regarding these children's safety other than sporadic checking in from one overworked and under-supported caseworker. The differential response model in the current child welfare system, and by current I mean underfunded child welfare system, puts children at risk of harm, and it also, on the parent side, doesn't protect the fundamental rights of parents to unhampered access to their children, which is a constitutional right. When these cases finally come before the court because the parents haven't been able to utilize the services in a way that addresses the problems and the risk to the family has continued and the difficulty with the families continued, these cases are extremely complex at that point, and the family at that point is in crisis. The opportunity to intervene in a manner that's helpful is all but lost because of how the case has been managed or not managed, as the case may be, to that point. There's also little trust between the agency and the parents, and the legal proceedings are often hostile and combative, which is exactly the opposite of what you want in these types of situations. In my experience, differential response, I believe, puts children at risk. As soon as a case is filed in court, there are multiple lawyers, there's a judge, CASA, CRB, who are all providing oversight and monitoring of the case. CASA and lawyers are regularly seeing the children in their home or foster placement, and they're monitoring services that are being provided or helping with services that are not being provided. In Benton County, our judge reviews every dependency case that is filed with the court at least every 90 days, and if the children are in foster care, of course, statewide, the CRB is reviewing those cases every 6 months. That level of scrutiny provides an additional layer of safety for children who are under the jurisdiction of the court, and that simply does not occur in differential response, which of course is exactly the point of differential response. But the problem is that the way differential response has been working in my experience is that it's not being applied all of the time for families who are low risk, which puts children at risk. Differential response also interferes with parents' constitutional rights, because what happens is When cases are assessed on the differential response track, oftentimes those cases frequently include a provision that restricts a parent from seeing their child or restricts that parent from having anything but supervised contact with their child. Caseworkers mistakenly believe that because the case has been assigned to the differential response track, they can implement a protective action 10 days or sometimes longer because they're not filing a legal case. But that is not wrong. That is wrong, and that is contrary to the law. Because there are no lawyers involved in differential response cases, no district attorneys, no AAGs, caseworkers routinely infringe on parents' rights to be with their children during a period of assessment in violation of their constitutional rights. Finally, as I've already explained, cases on the differential response track have no lawyers, no CASA, no judges. Limiting parents and children's access to these experts in the child welfare field eliminates any ability that we have to help these families in a meaningful manner. Lawyers often can help with parents who aren't or can't be engaged because of mental health, drug and alcohol, whatever their issues are, and we can help access services to children that are difficult to access. Additionally, oftentimes what happens is after these cases have been on the differential response track and they come before the court, the parents are at a point where they're at service fatigue is the best way to put it. They've already been referred to services. Those services aren't a right match for them. They're, here's a list of the services we have available, so we'll send this parent to this drug and alcohol provider because they have a substance abuse issue. Well, really what they really mainly might have is a mental health issue. And by the time we get those cases, it's very difficult to get those parents engaged in the services that are right for them because they've already been run through a bunch of services that might not be appropriate for them. CASAs can also seek out information from sources that caseworkers simply don't have the time to track down, and they can often help find services that caseworkers don't even know are out there. And I would ask the committee to consider in this area of in this era of inadequate funding to redirect the services and redirect the funding that's currently set aside for differential response to provide direct services to families, particularly in the area of being able to assist with affordable housing. Thank you for your time.
Thank you very much. And Jennifer, one thing you said to me this weekend that when we talked ahead of the hearing, you had talked about what your philosophy is in terms of long-term goals for families and kids. Could you talk about that a little bit, just to put some context on the words that you said?
Yes, thank you. Just a bit about my background. I've been a practicing lawyer since 1993. Prior to that, or 1996, sorry about that. Prior to that, I was a CASA, and prior to that, when I was an undergraduate, I worked with the Guardian Ad Litem program, which is similar to CASA when I was in California. And over the years, I have really come to believe, based on my experience and my representing, in particular, children, that we need to do everything we can to keep families and children together, parents and children together. Children who age out of the foster care system without living with their parents are at high risk for psychological problems, for drug and alcohol problems, for early pregnancy, lack of education, all those things that we don't want to have happen. And I've often thought that it would cost the state far less to move somebody in the home who could be a monitor, or I think of it as a Mary Poppins type person, that it costs to ensure that the children are safe than it costs to put a kid in foster care and to keep that child separated from their parents. And of course, I'm not talking about children that are at risk of imminent harm. I'm talking about cases where there is neglect, chronic drug use, things like that. Children really, really need to be with their parents, and when they're not, it causes them long-term trouble. And so my personal philosophy is that when it's safe, children need to be home.
Okay, thank you. Are there other questions for Senator Winters, thank you for joining us. Are there other questions for Jennifer before she heads back to court? No? Going. Jennifer, thank you so much for making time to call in and sharing your perceptions of how it's working. I think one of the things we're going to hear about the design of the program. Oftentimes in government services, we find that there is a design and a philosophy about how something is going to work, and how it actually works on the ground is very different. And I know that given your work with both children and parents and the role that you play in the community, that you've really had the chance to see this up close, not just once, not just twice, but dozens and dozens of times. So thank you for sharing that expertise and that on the ground, actually with the kids and the families perspective with us today.
Thank you very much for your time.
All right, and I'm going to hang up now.
Yes.
Okay.
Thank you.
Bye-bye.
Bye-bye.
All right. Did I actually hang up the phone? Yep. Yes. Okay. Thanks. So next we have Stacy Lake and Lena, and there's a PowerPoint in OLIS from them. And I am hoping that what you can give us is an overview of the goals of differential response, as well as I think most of us are aware that Dr. Richardson paused differential response, communicated with the legislature that he had very significant concerns about child safety and under differential response, and did not want to move forward with it until we could demonstrate that kids were safe. So I think recently the announcement was made that we're moving forward after all. So certainly interested in hearing what has happened that is ensuring that above all things that kids are safe.
Chair Gelser, Vice Chair Olson, members of the committee, thank you for allowing me to be here. My understanding, my name, for the record, thank you. My name is Lina Al-Husseini. I'm the Director of Child Welfare.
And my name is Stacy Lake. I'm the Differential Response Manager.
Okay, so shall we start with this and I can respond to some of these?
Yes, please.
Okay.
Thank you.
All right. So I understand that you know the history, so stop me when I'm repeating things you know already, but okay. So what is differential response? I'm sure you're all aware of it, but it's a family-centered approach for families struggling with issues of child abuse or neglect. DR is not an add-on to the system. It's part of the system. It's the front end of the system. DR stresses family engagement and helps connect these families to community with the desired result of keeping children safe at home. I'm talking from somebody who was in a DR state 3.5 months ago. I was one of the community partners. I had a caseload. I had MSWs on staff, so I know what it feels like to be part of a DR system and as the executive director of an organization that worked with the state in New York. So that's where I'm coming from that experience. We started here in Oregon to look at differential response in 2010 following the recommendation of the governor's task force on disproportionality in child welfare. The task force identified DR as a strategy to move Oregon towards a safe and equitable reduction of children in foster care. So that's the whole point of DR, is to treat families with dignity and to bring cultural competency to the practice with the aim of supporting families to keep children at home. We all know when a child is removed from their home, their whole trajectory goes downwards. I'm sure we're all invested in giving our children the best we can and giving them the best supports we can. Our surveys, basically, I just wanted to also add that in the 2.5 years that DR has been here in Oregon, our surveys are saying that our workers and our families are having a better experience. And at least one family who went through the system told us how much better their experience was after DR was implemented. So I'm going to give you some of the data that we have as well. So what is differential? Why differential response? Number one is child safety. Number two is family preservation and the safe and equitable reduction of children in foster care. The whole point of it is really to achieve safe, equitable foster care reduction and to keep the safety model. So the way it works, you have the traditional response, which is for the most serious reports, 2 tracks. The traditional response basically includes the most serious. Oh, I didn't. I'm not moving. Thank you. Actually, thank you. Sorry. I'm sorry. Here you go. The traditional response Here we go. The traditional response is basically the most serious reports of child abuse or neglect. These include and receive a comprehensive safety assessment based on the Oregon safety model and receive a disposition. The alternative response typically applies to reports that do not allege severe harm, and these cases also receive a comprehensive safety assessment based on the Oregon safety model. However, they do not result in a disposition. Both tracks allow families with safe children and moderate to high needs to receive agency-funded services without continued intervention by child welfare because the children are safe. And we provide, this is the early intervention approach. This is what I used to do in New York.
I have two questions about that.
Sure.
One is, what is the definition of safe? Is it just the absence of imminent today, severe life-threatening physical harm? And two, in reading through all of the materials on the DHS website and the materials from the review from the University of Illinois, it appears that in Oregon, the alternative response is used for families that are in moderate to high need, that no services are offered to families with low need, but in the vast majority of other states that practice differential response, only families with low need or low risk go into the alternative track, and all moderate and high need families go into that traditional track because of that enhanced safety. Why did Oregon decide to not intervene with those that are the lowest risk that could benefit from those services and put riskier families into this alternative track with less supervision when that's different than pretty much everybody else?
So let Stacey answer how they decided, and then I'll answer the second part of the question.
Okay. Chair Gelser, Vice Chair Olson. My name is Stacey Lake, for the record. We made some decisions early on that we had a group of people that were on a design team that helped us determine how we were going to implement differential response here in Oregon. We had about 35 people from different parts of the state, including staff and partners. And what we did was we looked at different states and how they implemented differential response. There are some basic tenets that make it differential response, but a lot of different states look different in how they implement differential response. We thought it was important. Safety was the utmost. Child safety is why we're all here. And so we decided that our alternative response and traditional response were going to look more alike than some of the other states do. So that's why we always must do a comprehensive safety assessment based on the Oregon safety model, whether it's an alternative response or a traditional response. Differential response is really the umbrella term. Alternative response and traditional response are two of those types within the system. So we decided to do it so that everybody would have a comprehensive assessment to determine safety. And how we determine safety is through that assessment. We gather information about the 6 domains, child functioning, adult functioning. I won't name them all. And then we make determinations based on the gathering of that information and the totality of the family conditions, whether the child is safe or not.
But if you've moved them into the alternative track, doesn't that also take out the oversight of the court in terms of timeliness of a CASA that might be engaged, a family's person? And in the report that we just got, that was just posted, it talked about that timely response of completing those assessments in Oregon is pretty poor. That 2 years ago, only 20% of the assessments were completed on time. Now we're at about up to half. But instead of 30 days, it's taking up to 192 days to complete those responses. And when they're done, only 10 to 20% of the people are getting services. So, and these are these moderate to high risk families with no other eyes on. I think the other thing that it showed was that in the fidelity review of these assessments in the alternative track, that of 40 safe assessments randomly selected for review, only 6 contained the documentation about why they were safe. So if they're in that alternative response, how do we really know that they're safe if nobody else is looking, we're not assessing on time, the documentation isn't there, and it's a riskier population than any other state is using?
Chair Gelser, Vice Chair Olson, thank you for the question. I do want to clarify that the track assignment, whether a family receives an alternative or a traditional response, is decided at screening. Then the CPS worker goes out, Child Protective Services worker, and does their overall comprehensive assessment. If at any time during the assessment the worker determines that the child is not safe, they take the same action they always should and would. In that case, would switch to a traditional track, and at that point, if it becomes court involved, the court and the CASAs and all the legal parties would be involved just like they are today.
But if that process takes 192 days to get to that on the end, what happens to the child in the process? And I mean, I think the other thing that struck me in this, and it was actually in Lena's email to us about restarting, it said that 50% of the time, screeners don't feel confident in whether or not they've chosen the right track for these individuals. And already they're allowed under the rule to put higher risk kids into that than any other state. So all of those things are confusing to me. If child safety is what's really promoting it, I see you have screeners that half the time say they're not really sure what they're doing, and they're not sure that they're keeping kids safe. That we have assessments, like we say we're doing all the assessments, but we're at like 192 days on these assessments. There's no accountability from these other groups. Hardly anybody is offered services, and among those that are, only half can even get them. And the assessments that are done on that alternative track aren't complete. Only 6 out of 40 are complete and comprehensive. And that's what the study says, the independent people that we've hired to come in. And so that, on top of we're taking kids in more dangerous situations and putting them into this system, and coupled with Dr. Richardson's concerns earlier that kids weren't safe in the system, is what is driving the question, and I haven't heard an answer to why are we putting riskier kids in the process.
The actual practice, and I'll jump into the... Okay.
Yes, Chair Gelser, Vice Chair Olson, I do think that we're getting to some of what your concerns are in the presentation that we've laid out. I think we'll touch on some of the exact words that you've mentioned, and some of the things that we know about that are a problem, and our plans to address them before we start back up with expansion.
Okay.
But it's still going on in a number of counties right now.
It's going on in half of the states, Chair.
So these issues that this outside researcher has identified, that is the risk that our kids in half of our state, like all the kids in my legislative district for now, are living under the risks that are identified in this report.
Do you want to go ahead? Okay.
Chair Gelser, Senator, Vice Chair Olson, half of the state is practicing differential response as of today from 2014 to the end of 2016, and those did not pause. That we didn't pause differential response practice. We paused expansion so that we could see what the results said, take a look. We were cleaning up our overdue assessments as well to try to get a better sense of where things were and address some of the lengthy assessments that you're talking about.
Right. Chair Gelser, Vice Chair, also members of the committee, yes, and I just want to point out over 15% of our cases do change track, if that comes to life. My understanding, we paused to really take a look at what we've been doing, look if this is working or not, and sort of evaluate the way we're going to go forward. So that was my understanding for the pause. Maybe there's things I don't know, but. So the early Oregon findings are children are just as safe in differential response counties as non-DR counties, if you look at the data, and we'll get into that later. Child safety is not diminished according to data, according to numbers. Families, workers, and the community partners are very satisfied. We've heard some really good things. Obviously, everything will have people for it and against it, and it's a new, different model in Oregon, so you're going to have both sides. But I believe dialogue is always a good thing, and we can always learn and make our practice better. But we really have to look at the outcomes and have a strategy going forward to help the kids in Oregon, to provide a vision for a transformation of the system and to lessen kids going into foster care, but provide safety to our kids. And for me, this is the way forward, in my professional opinion. So we're currently having an independent evaluation, as you mentioned. We've received the first process evaluation, which was the end of 2015. The first look at the outcomes was 2016, and we'll get our final evaluation in 2017. But according to the data, shall we go to the next slide?
Can I just ask a question about the data? Under the children are just as safe in DR counties as non-DR counties. Two questions about that. Is the flip of that true? Kids are no safer in DR counties than in non-DR counties? So it's roughly equivalent.
And Chair Gelser, that's how DR is. They tell you need 4 to 6 years to see a difference.
Okay.
So the fact that it's like that is actually part of the whole rollout of it. So, and if you want to add to that.
And then the other question about that, how do we compare if a child on an alternative track, if a situation there doesn't end in a disposition? So how do you, I mean, you could say there are the same number of founded dispositions over a period of time in an alternative track and a traditional track, but that would actually be concerning if the numbers were similar because there aren't dispositions in the alternative track. So what's the accountability measure where we actually identify whether the incident of maltreatment occurred to the child if there is no disposition?
Chair Gelser, Vice Chair Olson, members of the committee. I think one of the measures that we look at in order to help us with making up for what you're talking about with recurrence is re-reports. So that's why the many of the states that have done their evaluations for differential response have also looked at re-reports along with re-recurrence. So it helps us give us a sense of if families are continuing to come back to our attention.
Okay, thank you.
So this is just a look at what we could, currently we have half of the state practicing DR, but this shows you from 2012 to 2016 how we're moving in the right direction in terms of foster care, kids in foster care. And it shows you we chose the largest, the oldest and the largest, and we tried to put an indication of how we're doing currently in DR counties, and it shows you we're going in the right direction. Do you want to add to that?
Chair Gelser, Vice Chair Olson, the only thing I would add to that is this looks a little different than the findings that we received from the University of Illinois, and I just want to explain that. The University of Illinois are doing what's called a propensity score matching evaluation. So they are comparing alternative response cases to alternative response-like cases in non-DR counties and traditional response cases to traditional response-like cases in non-DR counties. So they're trying to do that comparison so that so you won't.
Oops, sorry. Let me go back.
So this looks as if foster care numbers are going down in some of the DR counties, and that is in fact the case. But because the evaluation didn't look at the DR counties over time and compare them to themselves, that's why it looks a little different than what you're seeing from the University of Illinois.
And question?
Multnomah
County, is that a DR? No. Okay.
Yeah.
Thank you.
You're welcome. Okay, so this basically, this slide shows you the child fatalities due to abuse and neglect, and I think that was one of the questions you had asked me. And you could look, I mean, 2012, 2013, there's nothing to compare. 2014, the green is the DR counties, and it's self-explanatory. And I wanted to give you also an overview of the sensitive issue information, the cases that we get, pertaining to serious injuries and fatalities. In 2014, 10 out of the 75 came from DR district in 2014. So 10 cases were from DR district where there was serious injury and fatality. In 2015, 53 out of the 95 came from DR districts. In 2016, 41 of the 87 came from DR districts. So it's and then the children in foster care, as you saw in the previous slide.
So I have a question, Lena, about this data.
Please.
So that's, first of all, I think we should take a moment and recognize that DHS has just put up a slide that shows that in 2015, 27 children were killed as a result of abuse and neglect, and 19 in 2016. These are stunning numbers.
Right.
But the question is, what do those numbers mean? I know that when there are fatalities in a year, so in 2015, we haven't had that number of certs, around kids that are DHS involved. So of that 27, how many had actually been involved with DHS in the 12 months prior that we could know in the 17 that there was a call or there was an investigation or there was an open case, or in the 10 that they were all alternative response, they were some traditional response in that county? Is this just the number of kids that died, or is this relevant to what DHS actually did with them?
So, do you want to go ahead?
Chair Gelser, Vice Chair Olson, these are only the numbers of fatalities as it relates to child abuse and neglect. We do not have the information that you're asking for at this point, but we could do case reviews.
So we really can't make any assumptions at all about how child fatality relates to differential response, because we know that there's differential response in some counties. We know that people die in some counties. We don't even know if DHS talked to these kids, so we can't make any conclusions about differential response.
All we can tell you is that many children died in DR counties, that many children did not. But we'd have to go through a case review to tell you exactly what happened. We're happy to do that, and we can present that to the committee as well. But this just tells you where the fatalities actually occurred, in what kind of county. And then I read the numbers, as you saw, and tells you also which districts where you had the serious injury. So differential response in Oregon, these are the districts that currently have DR, the ones with the star, and just to explain the process, and maybe you can jump in, but it was a stage implementation, and basically a stage implementation allows you to start and then pause, look back, see what's working, what's not working, fix it, and go forward. That's the whole idea of a stage implementation. And that's where we are at now. I mean, part of what I'm hoping to do when the memo went out, if you looked at the last piece of it, it said, we're going to review, we're going to make sure that we look at everything that's not working well for us. We're going to sort of really address these heads on and then start moving forward. But having learned from what we did right and what we did wrong, right? So that's the whole point of it. It was very strategic the way they did it. I have to applaud Oregon, because it was a very thoughtful process, and there were like more than 100 people involved in the process. They in the rollout, it was very inclusive. Part of the 6-month implementation in every district was to bring on community partners and understand how they can help. It was a very inclusive process, which I thought was very well done.
Were there kids in the process, like kids and youth that experience the system, that go through interviews, and were they part of the planning process?
Chair Gelser, Vice Chair Olson, we had a youth involved early on. He couldn't continue to participate, but we haven't had any other youth involved in the process. We've had parents involved at different points in the process, but not many youth.
Thank you.
Right. So we go to the next slide, which is nationwide. So over the past 2 decades, more than 2/3 of all states across the country have implemented or initiated plans for DR. In a 2014 issue brief from the Children's Bureau stated that generally DR evaluations have demonstrated positive outcomes, and that child safety has not been compromised. There were modest reductions in re-reports and child removals as well. But also the experience depended on the states. Some states had a much better outcomes after they implemented DR. Some didn't, but they're all on their way of getting where they need to be. I can talk to you about New York, for instance, because that's where I used to work. And in New York, in the mid-90s, in 1995, they had 902 children in foster care. Today, they have 20,539. Actually, not today. In 2012, they have 20,539 kids in foster care. So you could see the reduction in foster care, and it works in the long term. But it has to be a thoughtful process. It has to be really, we have to keep looking and learning, and we have to keep evolving to get the right system for Oregon.
And so, Lena, one of the things I learned just kind of studying for this hearing in the states that have done it and given it back, and I think Minnesota is in the process of discontinuing right now, that those states ended up discontinuing after a number of years because they started to see a marked increase in child fatality. So if child fatality increases and foster care decreases, is that, I mean, what would our goal be in Oregon? Is it more important for us to decrease child fatality or to decrease foster care?
My goal in Oregon is to keep every child safe. I want no fatalities, and I want our children to stay at home when appropriate. That's basically our goal. I'm not sure about what happened in Minnesota. Maybe you can fill us in, but I can tell you about other states that hasn't been their experience.
Chair Gelser, Vice Chair Olson, I know of some of the reasons why some of the states have stopped. Some have been because of a particularly high profile or tragic case. Some have been because resources were so limited that they decided that they couldn't do it any longer. And some have been because they didn't, the findings in their evaluations. I did not realize myself that Minnesota was stopping. I knew that they had also stepped back and paused to really relook at how they're implementing differential response. And they're one of the states that have some of the most robust evaluation and findings. So I didn't realize that they had decided to stop.
And we've put those in OLIS, and I think one of the reasons I was looking at that is I'm aware of at least 3 fatalities in Oregon in the last couple of years that are differential response involved or connected. And so that's, given the numbers of fatalities that we have and the small number of those that are DHS related, that large number connected to being put on an alternative track is concerning, especially considering the amount of money that we put into it when we have so much need for caseworkers and CPS workers at the regular level.
Chair Gelser, every fatality is a tragedy, and we have to look at it, and we have to assess it, and we have to analyze it, and understand if it happened because of systematic issues. But that doesn't deter from looking at patterns across the state and putting it all together and having a strategic vision to where we want to be. If we want every child to be safe, and we want our children to stay home where it's appropriate and safe for them, we need to have a strategy. But we also have to look at every tragic case, and we have to learn from it as well. So I don't think we're saying different things.
No, I don't. Right. Yeah, I think so either. Senator Dimbrow.
Actually, Senator Winters had a point first, and then I do.
I just wanted, you made the statement, thank you, Madam Chair, that child safety has not been compromised, and I hope it's never compromised. And the good chair commented, but has it been improved? And I think that really is the issue when we talk differential response, that if safety is our #1 priority of children, and that it has not been, quote, compromised, quote unquote, if we put something in place, it should be improved. And I guess I'm looking at the improvement. And when I see stats that says 2015, 27 fatalities, and 2016, 19 fatalities, I really wonder, what track we're on. Right. I just need to state that because those are alarming fatalities. And
Chair Gelser, Senator Winters, thank you for your question. With DR, you expect to see improved safety outcomes between 4 and 6 years into implementation. Oregon hasn't been on the track for more than 2.5 years, 3 years yet. So for you to see the numbers change and actually be able to count a decrease, you need 4 to 6 years. Currently, one of our challenges is the fidelity to the Oregon safety model and fidelity to DR. The DR is part of, it's the front end, but we're all looking at the Oregon safety model, and every one of our caseworkers should be looking at the Oregon safety model. And if you want to add to that.
If I may, Senator Winters, Chair Gelser, Vice Chair Olson, I think some of the other improvements that we hope with differential response in other states have found is improved engagement, improved family satisfaction, improved worker satisfaction, which would be, we would hope might decrease turnover, which may impact child safety as well if you can maintain workers who gain experience and learn how to do their jobs. The other thing that we believe that differential response will really impact, and I've seen along the way, is that communities come together, child welfare and communities together to best support the families and children in their own communities. So they talk about partnering in different and creative ways, or bringing different resources to bear that maybe weren't there before, just by coming together and talking about it more often.
So I'm going to skip this.
Senator Dembro had a question as well.
Oh, sorry.
No, it's fine, thank you. I just wanted some more clarification of, Chair, you mentioned the 3 fatalities that happened in DR. So is the assumption that if those children had been removed from the home, they would have been safer, and it was because they remained in their home that led to the fatality? I'm just trying to understand how this is.
I mean, I think that that's an important, as I understand it, so tell me where I'm wrong, the difference between traditional response and alternative response, you could be in a traditional track and the child could still be at home with a safety plan. But with that safety plan, there's some accountability, because the department can come, they can continue to maintain the services, they can require that the child be taken to the doctor, that drug and alcohol treatment be attended to. In alternative response, it's entirely voluntary. So if the family says, I don't want you here anymore, I don't want to take my child to the doctor, I don't want to go to I don't have to be there. I know the one that really sticks out to me, and it's in a prior OLIS, and I can send it out to you, and this was actually my constituent, a young woman that died not quite a year ago, GJ. She died actually of a bowel infection. Healthy 16-year-old girl, 15-year-old girl died of a bowel infection. She had 2 different alternative track responses, and everyone around her knew that she was decompensating socially, emotionally. She was suicidal. She was with caregivers that DHS knew were using methamphetamine. She was asking for help and saying that she was in crisis, but she remained in this alternative response category, even though it appeared that it was very high risk. And that whole thing is written out in the cert, and we'll talk about the certs later, but it pops up in some of the other recent certs, along with the screening piece, which I think is important, because the screeners, that's the place where the decision gets made. You call the hotline, that hotline worker determines, is this alternative response or is this traditional response? This data shows us 50% of the time they don't know if they're making the right choice, and almost every single cert for a child fatality over the last 3 to 4 years says the 2 key problems here are lack of a centralized hotline and adequate well-trained screeners who aren't receiving training, and inadequate comprehensive assessment, which this is an add-on to the Oregon safety model. And even Lois, when she was running it out, said one of the things we need to do is make sure everybody knows the safety model so that we can do the assessments.
Let me jump in. Chair Gelser, Senator Dembro, I am familiar with that case, but I don't know if I can talk about it, so I have to check with Director Saki. And if he's okay, I'm happy to come to you and talk to you about it, because it's a little bit more complex than that. I'm also not sure if the data states that in every cert it has been mostly DR, because we don't have that data. I'm happy to look into it. I said 3. I didn't say most every. Most every says that we need a centralized hotline and comprehensive because
assessment.
I don't have that data, and I've been looking into it, and I'm happy to do a case review and get back to committee with that information.
Chair Gelser, Senator Dembro, I just wanted to clarify that alternative response is not voluntary. Alternative response or traditional response, if it is assigned for an assessment, that assessment is just as necessary as it is in a non-DR county. The voluntary part comes in at the end of an alternative or a traditional response case if the child is safe at home and the family is found to have the needs and they are willing to do the family strengths and needs assessment. Because that child is safe, we would ordinarily just close the case. But what we're hoping to do now is, because we've engaged that family differently, try to connect them back to their community so that maybe they don't come back to our attention, and that's the early intervention part. That's the only voluntary part if the child's already determined to be safe. If the child's not safe, then they move to a traditional response. And many traditional responses wind up getting closed because they've determined the child's safe. So if it's assigned traditional from the start, they may go out and do their CPS comprehensive assessment and determine the child's safe and give the disposition and then close the case because the child's safe. So cases close in alternative and traditional if the children are safe. If the children are not safe, we take the steps we always have, except alternative switches to a traditional response.
Is it possible that there's a difference between the policy and the practice? Because I've heard from district attorneys in more than one county and child abuse assessment centers in more than one county, for instance, that, and it still surprises me that a physical abuse could land in an alternative track, but that families are basically being told it's voluntary whether or not to take their child for their Carly's Law exam, which is required by statute. And I've heard that from enough different places that it doesn't seem like it's one person,
Right.
that it's one thing. I've heard caseworkers tell me that it's frustrating when they have someone on alternative response because there's a carrot, but there isn't a stick to have compliance, to move forward, to engage in the assessment, to show up for the appointments.
Chair Gelser, yes, of course there's a possibility that there's a disconnect between policy and practice. The other thing I just wanted to mention is I recognize that the screeners in the statewide survey that the evaluator did said half the time they feel uncertain about the track assignment, and that was concerning to me as well. But I do want to let you know, as part of what we call continuous quality improvement, we are there coaching the screeners for the first couple of months of implementation, and then we come in and we do a fidelity review, and the fidelity reviews in all of the districts so far have been somewhere between about 80 and 95% fidelity. So they're practicing with more fidelity than they feel like they are. So they feel less certain than the decisions that they're actually making, but that doesn't make it fine. We're still going to follow up and do some more work in screening around the track assignment tool.
Cinder Winters.
Thank you, Madam Chair. How comprehensive is your training for your screeners, as well as now for your DR workers?
Do you want to go another add to it? Yeah.
Senator Gelser, members of the committee, Senator Winters, we built special training for the differential response counties that included we actually start out with 6 months of what we call readiness work, where we start presenting them with the concepts of how differential response is different than how they're practicing now. When we get to the actual training part, there's a half a day overview of differential response, which talks a little bit about the national perspective. Why are we even doing this? There's a half a day of family engagement and trauma-informed practice. We have a whole day of screening training. We have a whole day of CPS assessment training. And we have a half a day training that's called Partnership and Collaboration, where we actually bring some of the providers and partners in the community into the training classroom with the caseworkers as well.
Follow up. So what kind of training are you giving your managers and your supervisors?
Senator Wilson, Winters, Chair Gelser, the supervisors, program managers, district managers all come to these trainings.
And I want to go back to the hotline or the initial training, and what kind of training do they receive? Because that's your first point in some cases of contact.
Senator Winters, Chair Gelser, the screeners actually go through the overview training. They go through the collaboration partnership. They go through the family engagement and trauma-informed practice, and they go through the full day of screening training as part of the DR training.
And are you doing this in-house, or are you contracting that out?
Chair Gelser, Senator Winters, we actually contracted through Portland State University to help us develop the curriculum, but we are doing the training ourselves with our staff on our team, and we've actually made adjustments to the curriculum with each round because we ask for feedback, we get evaluations, we've used that feedback to go back and make changes to the curriculum, as well as some of the challenges that we see. We make clarifications, or we've made adjustments to the track assignment tool to make it more clear So we've tried to really use the staged implementation to make corrections and improvements as we go.
Right. Chair Gelser, Senator Winters, and you'll see in the coming up slide, one of the challenges for us was the screeners. They felt they needed much more coaching, they felt they needed much more training, and that's something we're going to be focusing on very intently and thoughtfully about giving them the information and the training that they need. And the ongoing coaching. I mean, that's part of the practice and that's part of the model. So where are we now? Community
Can I just
engagement.
ask one more
So
question
this is-
about that?
Yes.
So it's coming, and they need the training, and we have all of these child fatality reviews that say we have fatalities that are linked to multiple closed-it screening. We have, multiple fatalities that are linked to screening problems, and yet we implemented something that requires an even higher level of sophistication for screeners, and we have this high degree of turnover. I think I'm trying to build on what Senator Winters is saying. It's with so much at stake, it's hard to understand how a 2.5-day training in a 6-month buildup in a system that we already have is identified as a systemic cause of child fatality in Oregon, why we would make it even harder.
Chair Gelser, Senator Winters, and you can finish. I don't think you can attribute all fatalities just for this. It's part of a systemic problem, whether it's differential response or non-differential response, right? You saw the numbers, they're across the board. So we have a problem. I mean, the biggest problem is actually, lack of staff and overwhelmed staff and lack of resources. But DR is a way forward because you're going to be getting, and which brings me to community engagement. You're going to get more people engaged. I mean, the one thing you have a resource here, and I've heard it across the board. Everywhere I go, people tell me, how can we help, right? You have a community engagement is another resource that we should be looking into. So strategically thinking, looking forward, this is going to be most cost efficient. This is going to be adding another resource to the mix, which will make us provide better services for our families. So it's not, I think we have to look forward at the long term, not just the short term, to be quite honest.
And I guess it's that old thing of you throw the babies, like which babies do you rescue? The ones that are getting thrown off the bridge or the one that are
I want to
down?
rescue all of them.
And I want to rescue all of them too, but in a resource strapped, it goes back to what Senator Winters was saying, where you showed us that the data says kids in DR counties aren't any safer than kids in non-DR counties. I believe the allocation that was made under Governor Kitzhaber several years ago was like $89 million, which is what I read, which is a big investment when we know that we desperately need training for our screeners and we desperately need more caseworkers. And the question is, right now, could we make kids safer by redeploying that $90 million from a program that is not increasing child safety, that in the best case scenario has equal results and makes people confused? Would kids be safer if we could use that money to shore up the foundations of this, which are the Oregon safety model and screening, and train people to be family focused? Because it doesn't seem like there are any of these things that you have to do differential response and be on an alternative track to provide family-centered services and engage the community if people are willing to step up and help.
Chair Gelser, I mean, I thank you for that. I appreciate it. In terms of differential response, all data, all research shows that you need 4 to 6 years to see a difference. So we're not even there yet. We haven't even done 3 years. In terms of using resources, in my professional opinion, you have to have a strategy. We know we have a problem. We can't keep doing what we've been doing because it's not working. So in my opinion, we have to have a strategic vision to move forward. We have to transform child welfare. And we have to be very thoughtful about where we're going. We can't keep doing what we've been doing, because either way, it's not, if we stay doing what we've been doing, it's not working. So I don't know if the data says this way is better than, the old way is better than differential response. Differential response has proven in many states to really impact safety, impact children in foster care. So there is a way forward if we're very thoughtful about it. And if you want to add to that, I'm not sure. Okay. So community engagement. And basically, to go back to we can't do this alone. We have to have community partnerships. And I'm speaking from experience when I tell you, as a community partner, when I used to do this, we worked hand in hand with DHS, with our equivalent, ACS. And we very much looked at the safety considerations. I had MSWs on staff. I had people who were very thoughtful and knew what was happening. And it was really a partnership. There was there was a lot of cultural understanding. There were wraparound services, and we worked together. As a community, we supported families who were in crisis. And I can tell you from my experience, I believe it works. So, and I think we need to use more of that in Oregon, because you have communities who are invested. I've heard it across the board. Everywhere I've been, communities, the number one question I get asked, how can we help you? Just let us know how we can help you. And I think DR is a way we can work with communities. So the benefits of practice change, which is, I guess, what we've been talking about earlier, is keeping the children safe in their home when they're appropriate, positive relationships with community organizations. Workers feel supported with the increased training, and if they feel they have more knowledge about their practice, and families say they are positively engaged. Families feel that they are supported by community, supported by the state. We're helping them transition. We're helping them get out of the bad situations they're in. If it's possible to do that and keep the children safe and well cared for, I think that's the way we should be going.
So is that data based, because that was the other thing that jumped out at me, and I'd heard that before, but in the University of Illinois, I'm trying to find the page. It talked about a very low participation rate of the parent survey. It was like 1% of the families that participated returned the survey, and it was actually a lower response in the differential response communities than in the non-differential response communities in terms of parental impact and that feedback.
Chair Gelser, that's correct. The survey response rate was very low, and the University of Illinois, the evaluator, has made some adjustments to be able to get more information from more parents. So they're doing that now.
Okay. But the comment that families feel more engaged, that is based on that very limited survey where in the report it says don't rely on this information because the survey sample is so small.
Chair Gelser, that, and we've had parents that are involved in the rollout in different communities that would also probably, I know, would answer that way.
And we actually had, and we can send you also the narratives that they provided to support that.
Thank you.
Thank you. So child safety outcomes today, children are just as safe in DR counties as non-DR counties. Child safety is not diminished. Community partners and tribes have told us they are more satisfied, and there's no statistically significant differences in re-reports, recurrence of abuse, or child removal. Hopefully, over the next 3 years, what we're hoping to achieve is re-reports reduced over time, so I guess it speaks to some of the concerns of the committee. Re-abuse reduced over time, foster care entry reduced over time, long-term costs are neutral, and to reduce disproportionality. And I can speak a little bit about the University of Illinois staff survey, if the committee would like, some of their comments. But some of their comments across the state's attitudes towards both differential response and the Oregon safety model are very positive. Over 80% felt that these initiatives promote the safety and well-being of children and families. Attitudes towards the Oregon safety model are more positive in DR counties than non-DR counties. So it actually works hand in hand.
Madam Chair.
Yes, Senator Winters.
As you look to the future, would you look at perhaps that I know you're probably putting a lot of emphasis on the training of the screeners in the front end and some the caseworkers or those that are involved with differential response. Don't you think at some point that your training should be uniform and consistent with all of your personnel?
Chair Gelser, Senator Winters, absolutely. We do believe it should be consistent, and that the differential response training that we're delivering is consistent. I imagine the Portland State University core training is also consistent. I think one of the things that has been helpful with differential response is the coaching model that we've used, and that's having consultants, we call them, coaches out in the field helping staff make not only the technical changes, which are many in the beginning, but those adaptive changes that take longer. So having somebody there supporting you, helping, like I said, we have somebody sitting with the screeners probably for the first month of when we start, and often longer. So I do think that we need to increase that or go back and do more intensive coaching, because when we move on to the next districts.
Follow up. Then are you at any point thinking about perhaps maybe you need to centralize this?
Chair Gelser, Senator Winters, centralized screening?
Well, even your training. I've been wrestling with this issue for some time. And of course, when I was with Children's Services, it was centralized. It was a part. So anytime you had, whether it was a policy change or any other changes, you were able to provide and to be able to train your staff statewide, because you're all spread out all over the state, as well as training your managers and supervisors so that you have the ability, when these new policies come down, that they too have a clear and understanding with what is occurring and how then to be able to assist their employees.
Chair Gelser, Vice Chair Olson, Senator Winters, I do believe we have a central training system between Portland State University, and again, the differential response training at this point has been by a team of my staff, but the intent was once we got to a certain point, it gets built into the Portland State University core training so that all the new staff are getting that when they come in, and we don't have to continue to do makeups in the field and those kind of things.
And I would add on to that, kind of that centralization. There's a document that DHS provided to us in November 15. It's fact sheet centralized screening. It's also in OLIS, and it starts by talking about fatality reports, or saying that there needs to be centralized screening. And then it goes on to say, and this is DHS paper, with the implementation of differential response, it is again clear to the department that some method is needed to ensure fidelity to the DR model, especially now that there is a category of families that would have interaction with the department but would not have a dispositional finding at the end of the assessment. Ensuring the right families are put into the right track is critical to the success of the model, and that decision is made at the screening level. And again, going back to 50% of the time, the workers are saying they're not sure what they're doing, is incredibly concerning if half of our state, that's the system that our kids are being fed into right now.
Thank you, Senator Gelser. And that's part of the lessons learned, and I'm going to get to the challenges as well. But we have to take time to plan and prepare and be very thoughtful about the way we roll out. I've told staff, even if it takes me a year, I want to really be very thoughtful about the way we're doing this. To solicit and use stakeholder buy-in. I think it's very important to be inclusive in everything we do and to hear everyone. And I think dialogue just promotes better practice. So I think this is really good. Facilitate peer-to-peer learning, ensure service availability, and strengthen community relationships. I think that's huge. And implementation of change is a developmental process, and it's a science to change, right? So hopefully these are things that we're going to be very attuned to and be very thoughtful about. Do you want to say anything else, or go to the next one? Challenges. And I'm going to start with the big one. Our biggest challenge is staffing. Staffing shortages. People are overwhelmed, overworked. That's the workload it's very high. The other challenge is fidelity to the Oregon safety model. We have to keep training people. We have to keep coaching. We have to be watching that people understand the Oregon safety model very well. fidelity to the differential response model, the same thing, and fidelity to screening, exactly what Chair Gelser had just mentioned. Accountability, I think the system that we're going to go forward with is going to ensure accountability as well. And there's going to be a culture change where we're all working together, we're all invested, everyone, whether it's a community partner, a staff caseworker, there's going to be a culture change, I hope, as we move forward. And then improve data, some of the anecdotal stories that we've been hearing. I don't have data to know either way if there's a pattern, so I have to start looking at those.
And I would argue on the improved data, I don't know that we have the data to demonstrate that kids are not any less safe or that child safety isn't compromised. I still don't understand where the data comes from, and it would be helpful if you could come back and describe how we do that, since you don't have dispositional findings to compare.
And Chair Gelser, I'm happy to do that, and I can send you all this information to the committee as well. Did I forget anything? Okay. Moving forward, I'm just going to reiterate what we're going to be focusing on, which is number one is child safety. Number two is screening, really looking at our screening model, family strength and needs assessment, and coaching support for our staff, so they know and they feel very well versed in both the organ safety model and differential response. And the last is how you can contact me and everyone else. Any questions?
Any other questions for this panel? And then we'll bring the next one up, and then give them a chance to come back up. Senator Winters, did you have, or you said no?
No, I'm just sitting here, my head's whirling.
Okay. Oh, very good. All right. Thank you both very much.
Thank you so much.
Okay.
Thank you.
Next we have Mike Regan, Sue Skinner, and Carrie Reek. And can you pause for a minute? We made a mistake in our motion, so we have to redo this motion. The date was wrong in the script. So I'm briefly opening a work session on introduction of committee measures. So if you just say that.
Did I
Please.
not ask you, Madam Chair, to repeat?
Yes, you did. It's only one.
I did.
Just right here. You just say, I move to.
I move to reintroduce LC 2712 dated December 2nd, 2016 as a committee bill. Sorry about the mistake in the motion script.
Senator Olson moves to reintroduce LC 2712 dated December 2nd, 2016. Is there any discussion? Is there any objection? So ordered. Closing the work session on committee measures. Back to the informational hearing. Welcome. Mr. Regan, do you want to start for us?
Thank you, Chair Gelser.
Thank you.
I would love to, and fellow senators, just to give you some perspective on.
And you have to introduce yourself. For
Michael
the record.
Regan, R-E-G-A-N. I'm a deputy district attorney in Clackamas County and have been for 32 years. I want to start by making sure it's clear that I am a supporter of the agency, DHS. I've worked with them for about 25 of those 32 years, and I recognize that they're in a tough position every single case. Having said that I'm a supporter of the agency, I am not a supporter of differential response. As a chair of our local multidisciplinary team, we, Dr. Skinner from our Child Abuse Assessment Center and myself and law enforcement and behavioral health and mental health and DHS workers and a whole bunch of people meet every month, and we meet in a committee, in a subcommittee, multiple subcommittees, the Child Fatality Review Committee. I have all that experience, and we try and review cases locally to find out what's going well, what's going poorly, and I'd like to start my remarks by just giving you a sense of what I don't know, which is the scariest proposition. In Clackamas County, differential response rolled in December of 2015. So our experience is about 14 months old. And over that time period, the number of cases that the district attorney's office and the court system handle has been cut drastically in half. We used to do approximately double the casework in our local court system that we're now doing. The referrals to our children's center, our sexual abuse clinic, are reduced in half. We pride ourselves locally on trying to follow the law of the multidisciplinary approach. I've been a prosecutor long enough that I was here before the MDT model, when it was just police officers interviewing kids, and everybody decided that wasn't a good way to go. And we developed this multidisciplinary approach to try and bring the strength of numbers into each individual case. My biggest concern about differential response is that it removes that multidisciplinary focus and lays all the decision-making in one agency. And when we try to review cases that are of this type, we get the same type of presentation, no disrespect intended to the director, but you can actually see faces freeze up and people not speak honestly, and analysis not being done, because there appears to be a fidelity to the jargon or the movement of differential response, and not a focus on each individual case and what's best for that child. So it's my belief that if you design a system that's multidisciplinary, and through the Oregon safety model and the differential response in particular, you take half of the population and you have only one agency deal in those cases. I could not tell you if children in Clackamas County are safer, because I honestly do not know. And that's my responsibility. But those cases go off into the alternative track. Those records are confidential. Those cases are not reviewed. They do not see the light of day by a review by a district attorney, by a review by a court system, by a review by defense attorneys that are representing children. And of course, people like a system that doesn't involve court involvement, because nobody likes going to court, especially untrained, young, inexperienced caseworkers. So I understand why DHS values a model that doesn't stress court involvement, but it is that very transparency and the tension of a adversarial system that is the stick, to use your analogy, that you sometimes need. Our primary focus is cooperation and collaboration. We want to see children remain in homes. We don't want children in foster care. We understand the drive to do that, but we don't believe there's a correlation between differential response and fewer children in foster care. We believe we can have fewer children in foster care and still have a transparent, open system through the courts. And so that's my basic premise. I don't want to run on. I have lots more I could say. Just in reaction to the comments from the presentation, I don't think we can say that the community partners are all satisfied, because from my position as a representative of our local MDT, almost all of the partners are not satisfied. That's our experience. There's one agency, because I want to be honest and accurate, that has said they're just fine with differential response, and that is our local law enforcement. And I believe the reason for that is that our DHS caseworkers are still calling out police officers and still investigating cases. But then, if it goes half the time to differential response, those police officers are never again involved in the casework, because they're not subpoenaed over and over to case after case review. They're not going to court. They're not being yelled at by judges. They're not having to do anything more than an initial investigation. But that investigation is occurring. So I want to make people rest easy about that. More particularly, Dr. Skinner has front-line experience and the same concerns I have. I'm looking at the macro level and our numbers and the reduction. And so our concerns are, we're not seeing these cases anymore. And that scares us, because we believe, just like DHS, that we care about community safety and that we're legislatively and independently sanctioned to protect child safety, and that's what we want to do. And we're not able to do it anymore like we were a few years ago, because the case counts are going dramatically down. I want to give you just a final example of that. In Clackamas County in January of 2016, there were 174 assigned cases through the local DHS office. The number of petitions filed in January of 2016, 0. The following month, it was 4 in February of 2016 on 229 assignments. The month of March, there was 4 petitions filed on 199 assignments. It goes like that through the whole year. We've got 2 deputies assigned to this casework that were doing 50 cases easy every year. Now they're doing 4 or none. And we just don't believe that that's because the case of child abuse is reduced, because we know from our research that the hotline referrals have gone up every one of those years. In 2014, 15, and 16, the numbers of hotline cases in Clackamas County have increased. I had it here. They were 6,162 referrals in 2014, 7,295 in 2015, and 7,672 in 2016. And yet over the course of that increase in hotline referrals for abused children, our numbers have gone like this. Their numbers at the Children's Center have gone like this. And what we're hearing from DHS when we try and investigate this is, well, the children are safe. And to use some colloquialism, I guess I just have to trust that, because I can't verify. And I don't like the lack of transparency in government. I'm scared about it. Thank you.
Thank you. And can I ask one question? There was something you mentioned when we talked this weekend. Could you talk about, you had given some numbers about the percentage of cases that were going to alternative response, and particularly what's happening with neglect?
Yeah, there are 50% of the cases, slightly more than 50% of the cases in Clackamas County over the prior year since differential response was instituted are going alternative response. And almost all neglect cases are going alternative response. And from my experience and training, neglect cases can often be extremely serious cases that involve abuse as well, but if you don't follow up and ask the questions and involve the court system, you're never going to find that out. Prior to differential response, we had the ability to do the same thing on a case-by-case basis with voluntary services being offered by the agency. But we didn't have a whole movement that was designed and directed us to have fidelity to it. My concern is that this movement, as I would call it, is coloring individual caseworkers' ability to do the right thing in individual cases, because their supervisors, their trainers, everybody's telling them this is what we're going to do. And we can see it in our case reviews. The frontline caseworkers don't talk, the supervisors take over, and there's a discussion about how great DR is. And that's happening too often. And so they can't do this alone. They have to involve their community partners. That was the quote the director gave. And I wrote it down because it struck me as odd. I believe they're trying to do it alone. And I don't understand why any agency within state government would want the ticking time bomb of insulating yourself like this so that when that child does die or is seriously harmed, you're going to be responsible, and that you didn't involve your community partners like the courts and like the DAs who can work with you to help you. That's what we want to do. We want to help DHS. We understand that their job is extremely difficult and that they're damned if they do and damned if they don't. But it's not all their fault if they'll give up some of that responsibility and work with us. And I'm seeing the direction of child abuse going in a direction I'm not comfortable with.
Madam Chair, I apologize. My computer blew up, and without my computer, I'm stone cold ignorant. I've looked through everything now that they've got me back running and in good shape, but I have yet to see an exact definition of what differential response is. And you know, if you can't define it, I see in there they talk about it, but if you can't define it, what does it do? Could you give me a definition of differential response?
I can't. I can tell you the presentations we've received and the trainings we've received, and I can tell you that from the statistics we've requested from our local branch that all neglect cases are going that direction, and that physical abuse is sometimes going in the direction, that sex abuse is never going in that direction. Those are the things I've been told. But threat of harm and mental injury, the other categories of abuse under the statute are going in a mixed bag in both directions. So Dr. Skinner also believes, I believe, not speaking for you, that the drug cases are exclusively going in that direction in our county, and it's cut down a tremendous amount of concerns we've had about parents that are using methamphetamine and heroin, and then we go in, we take a deeper look, and we find out there's a lot more going on. But in a differential response kind of approach, we never get there. Those cases don't show up anymore. And we know that methamphetamine and heroin is exploding in our state. It doesn't make sense, as well as the hotline referrals going up, the drug abuse is going up, and we're not seeing any referrals into the official system anymore.
So, if I may.
Yes, of
follow-
course.
Thank you. So basically, differential response is a broad term with no underlying foundation?
I'm not going to speak for the agency. They do have a lot of definitions of it, but I believe that it is what they define it to be. And since we do not see the cases that they choose to route in that direction, we don't have any ability to judge whether that is the right call or not. It's not being left to us. And the multidisciplinary approach is waning. And when in our case reviews, raise this, I've been told that, well, we've read the protocol, we've read all 36 counties' protocols as an agency, and our model of DR response is consistent with the local protocols for multidisciplinary teams. And I beg to differ, because it's not. Because our local protocols say that all the multidisciplinary partners get together and we follow a plan to ensure child safety, which includes a referral to our designated medical professional, and a law enforcement investigation, a referral with the DA, and then a determination if petition should be filed. And none of that is happening in these cases, which they are self-selecting.
One last
thought, yes.
And this is just a thought. Maybe we need to change. It's a very nice term, differential response, but maybe we should change it to response of a different type. Because it doesn't seem to know anybody knows where it's going.
I think it's jargon that sounds good.
Thank you.
Dr. Skinner.
Hi. Thank you so much for allowing us to come here and speak. My name is Sue Skinner. I'm a child abuse pediatrician. I've been working in the field for about 23 years, and I've been in Clackamas County at the Children's Center for nearly 7 years. Just to answer your question first, this is from the DHS training presentation. I don't mean to speak for them, but I had printed it off myself to refresh my memory on the definition. And they had two different definitions. One was an approach that allows CPS to respond differently to accepted reports of child abuse and neglect based on factors such as the type and severity of the alleged maltreatment, number and sources of previous reports, and willingness of the family to participate in services. And then the more specific definition for the state of Oregon is that differential response is a system of response to reports of abuse and neglect that contains at least two distinct response pathways. The term DR will be used to refer to the two-track system. So I think it's just, and again, not trying to speak for the agency at all, but I think it's just a definition that says it's not a one-size-fits-all for all cases that come in and we decide to assign. That the calls coming in and the decisions to assign the case are the same, but which track that assignment follows is differential response. That's my understanding. And that was the extent of my expertise on DHS. I also would like to start off just by saying caseworkers and people that work for DHS are probably the ones I respect the most because they have the hardest job of any of us. And I say that time after time, and frankly, we say that at the majority of our MDT meetings. Really great people doing really hard work, and I think the multidisciplinary discussions sometimes are a little tough because I think it's a frequently attacked agency, and I respect the work they do. So this discussion for me, is really about policies and not people, and we really appreciate the people that we work with in Clackamas County. What really stands out to me is just the complexity of the problem. And Mike talked about that a little bit. The complexity of the problem of child abuse and neglect really necessitates a multidisciplinary approach. And legislators realize that, as well as those of us that do the work. And that's why there's a lot of, that's why we're here today. And that's why the law talks a lot about a multidisciplinary approach, multidisciplinary team, and all those sorts of things. And I would liken it to in a medical clinic. If you have cancer, just having only your cancer doctor is great, but probably better patient outcome if you have your cancer doctor and you have a nurse and a case manager and maybe somebody that does yoga with you for your mental health and a surgeon, and all of you working together for a really complex problem is really going to give you better patient satisfaction and outcome. So I think we need all of us in our MDT, and we need all of you as well. And I think when a system develops where working with children and families becomes a little more siloed, even a little more siloed, it doesn't work as well, because to even have one fatality or one bad outcome is too much. So as they talked about in the presentation before the rollout in our county, they started having meetings in Clackamas County about 6 months before the rollout. And I felt like it was handled really well. I appreciated that people from the state level came and said this is the unified approach for the state, but we want to tailor it to counties. So I appreciated I came in with zero knowledge. There was 20, 30, there was a lot of people there representing a lot of different groups in the community. Probably from that first meeting, I became anxious about it when I heard that 60% of the cases would become alternative response and 40% traditional response. And when I tried to understand how that decision was made, so this is even before the rollout, this is in the informational sessions, it was the traditional response would be the ones that exhibited serious or imminent harm or present or probable danger. And I asked for further clarification on that. It was basically all sex abuse would stay traditional response. I'm paraphrasing, but all sex abuse would stay traditional response, and severe physical abuse would stay traditional response. Virtually everything else would be alternative response, which would mean pretty much all neglect. Not as bad of physical abuse, I think, meaning like not head trauma and broken bones, and then threat of harm and emotional abuse. And having done this work for so long, as Mike said, some of the really chronic neglect cases are really, really complex, and it requires a multidisciplinary approach to best work with the families and the caregivers and the kids. So I was uneasy about that, but it really was apparent, like it was happening, kind of get on the train. So I was trying to understand it and keep those notified within Children's Center about what was going to happen. So our rollout began in December of 2015, and for our center, so I'm just going to talk about statistics for our center, and I don't claim that they represent the state at large, but I can just talk about our numbers. December, January, February, we started seeing a decrease in referrals from DHS, and in particular, we started seeing a decrease in referrals around neglect and drug-endangered kids. That doesn't mean all children that live in a home where we're worried about neglect have drugs going on, but a lot of them do. So at our center, we do hair testing and urine testing when there are worries of drug use in the home to really help identify the risk factors the child's living in. So I brought those concerns at the few follow-up meetings we had after the rollout. The couple of concerns that we identified early on was what felt like a decrease in neglect and drug-endangered children referrals, and also really some confusion about the Carley's Law cases, so the acute physical abuse. And the confusion around those for the first few months was that alternative response is, if you look at the kind of the slide that tells about how it differs from traditional response, rather than individual interview, it was described as a family interview. That was worrisome for us because oftentimes the person that's injuring the kid is in the family, and so we were concerned about that. We also were seeing, and I was getting these concerns because I supervise the clinical aspect, so the people in our clinic that are getting the calls were coming to me for clarification, that cases, Carley's Law cases, were being assigned AR-IR, meaning alternative response but immediate response. And I would look at those and think, how is a caseworker supposed to do this? They're supposed to, we've identified it as an immediate response, but it's on the alternative track. That would seem really hard. I think that felt really confusing to the workers as well. So I brought up some of these concerns at the follow-up meetings we had, which maybe stopped last summer. And then in this fall, as the year started going, we really were able to gather more data. And I think part of why we're here now is we as a county started talking about it December of last year, because that's when we were a year out. And then now it's nice because we can have a full year data to compare to. So these are just 3 things that I wanted to point out that have stood out for our center. Referrals to us from DHS decreased by 16% in 2016 as compared to years prior. So 2015 to 2016 went from 229 to 193. So our referrals from DHS are down. Referrals of kids that we saw for Carly's Law cases, so acute physical abuse, were down markedly from 3 years prior. The 3 years prior, we had 43, 41, 55, and then last year was 32.
And just to be clear, Carly's Law is mandatory. That's not discretionary, correct?
Right. So, Carly's Law is mandatory that the children have a medical assessment within 48 hours. The law says that ideally it's with your child abuse center if you have one. At times, prior to alternative response, that has been hard for caseworkers at times. Because sometimes, for a variety of reasons, it might be transportation, it might be mistrust of the system, it might be a lot of things. A caregiver might want to take the child. It might be they have been to our center before and they're afraid we're going to ask too many questions. I don't know, but it's they will elect to take their child to primary care, and then we will review the records. I don't think that's optimal, but sometimes that has happened in the past.
And to be clear, it's also against the law, but the law clearly says you can't go to your own doctor for your Carly exam.
So a decrease of that degree was concerning for us. The one that really stood out for us, comparing 2016 numbers with the 3 years prior, was our referrals for neglect cases and drug-endangered children. And the number, typically that had been about a quarter of our referrals were for kids where there are concerns of neglect or drug endangerment. For DHS cases, that's almost 50% of the cases of abuse and neglect are neglect. So for us, the 3 years prior were 138, 115, and 119. Last year it was 54.
Could you say those numbers one more time?
So the 3 years prior was 138, 115, and 119. And then last year was 54.
For medical assessment.
Referred to the Children's Center for concerns of neglect and drug endangerment. I can't say that that's due to differential response. The timing is quite coincidental, but it could be other reasons. We've just been pretty consistent for a number of years to have around 100 of our 450 kids that we see a year for neglect, drug endangerment. So to cut it in less than half of that, right at the same time of the rollout, was concerning. And for me, I would echo then what Mike said about cases not coming to the DA's office. I don't know. Have all those kids in homes where there's concerns of drug use been made safe now, and so we didn't need to see them? I always go back to Oregon Revised Statute, where it says community assessment centers in Oregon are there to ensure that every child reasonably suspected to have been subjected to child abuse receives a skilled, complete, and therapeutic child abuse medical assessment. And that's not happening. So I guess what I would say, part of what my struggle was, and then I'll stop and allow you to ask questions, but what I struggle with is what I feel like is the subjectivity of some of the words that we use. And I think you asked about that before, like what does safe mean? And we say children are safe, or we've made them more safe. I don't know what that means, really. And when we talk about differential response, it's phrases like serious or imminent harm and present or probable danger. And kids are in homes where caretakers are actively using drugs or drugs and alcohol. are at a lot of immediate risk to me, serious or imminent harm or present or probable danger, and long-term for their adult lives as well. So I struggle where I feel like some of the words that we use to direct our approach can be subjectively defined. I think I'm going to stop there.
Thank you. And we're almost out of time. We've got Carrie Reek still. Thank you, Carrie.
Good afternoon. Thank you, Chair Gelser and Vice Chair Olson. My name's Carrie Reek, and I'm the Executive Director for Benton County CASA program, and I'm here to speak on just our program and what we're experiencing and our experience with differential response. When differential response was rolled out in Benton County, there was significant confusion. The implementation was implemented within our county about 6 months prior to when we were scheduled to be rolled out. So there was a lot of confusion regarding that. And we were lucky enough to be able to bring in the consultants for both the Oregon Safety Model and Differential Response to help clear up some of the confusion that had happened around it. So it was a real struggle for us initially to figure out what was going on, what the plan was, and everything. So after that's been rolled out, what our hope was at the time was that the alternative track would actually be used for the parents that were the lower risk, because we all want to prevent child abuse. We don't want to wait until it becomes an issue where we have to do something more than providing parents some basic services to be able to stop it prior to it happening, right? So our hope was that's really what the alternative track was, is to spend more time focusing on those parents that were coming in, where the reports were coming in, where we were able to determine that. But like everyone has said, it became the mid to higher level risk cases that were going on the alternative track, and really no then supports for the families that were really at the high risk level unless they truly voluntarily engaged in the services. So I think that's been part of the problem. I know that the caseworkers' workload is a huge problem. The training of the caseworkers, the screening is definitely a big issue. The consistency of how it's implemented between counties. I hear from other CASA programs throughout the state that possibly it's maybe working in their county. So I think that's really what it comes down to. When we talk about the reduction of children in foster care, I think it's important to kind of separate out a few factors, and one of those is there's a real focus with the legal partners and community partners to keep the kids in home when at all possible. So previously, and I've been an advocate for about 14 years, and previously, it was almost like children were just taken into care, and without with a lower bar, right? There was a lower bar of abuse before children were taken into care. Now we're trying to do everything in our power and engage as many community partners together to be able to support that family, help them build the natural resources, which is really what they need, to be able to keep the children at home. So even in legal cases, many times the children are still at home with their parents. So we call them foster children. However, they may not necessarily be in foster care, and I think that's a definition that gets confused between all of us in that manner. I support the work of caseworkers. It is incredibly hard, and we try and partner with them as much as possible. We may not always agree with them, but we do. We all know that we want children to be safe. And so I think that's really to me, it's differentiating between what we're talking about, what services are being provided at what level, and are those appropriate to not only react to the child abuse and in the appropriate way and services that the parents need, but also prevent, right? Intercede as much as possible, provide those wraparound services, and develop the natural support so we don't have children being abused. I will say that I believe children are coming into the legal track with a higher level of trauma than what we've seen, and I think that they're staying in care longer because they have a higher level of trauma. The parents are more down a bad path, and it takes longer to pull them back. And So in my mind, you know, it's not, differential response is not a bad thing. I think what we cannot tell is where it's working, is it the appropriate population, and are we doing the right things to ensure the services? And I also sometimes think that when kids go on the alternative track, when the parents go on the alternative track, that the children aren't getting the services they need. We're not ensuring that they're getting the appropriate assessments so that they get the services they need to kind of overcome and refocus on what the family unit is in a positive way. So thank you.
Thank you. And I just realized we're out of time. It feels like we've been here for a few minutes, for only a few minutes, and apparently it's been almost 2 hours. So we will come back to this and give you a chance to come back up. We have to turn over the hearing room. We have a full schedule for Wednesday, so we will reschedule the public hearings on Senate Bill 268, Senate Bill 819, and Senate Bill 820. Are there any questions for this panel before we all take off to our next hearings?
Where do I start? We'll carry on.
All right. Thank you all very much. And I just want to thank, I think something that both Sue and Mike said is really important. This is a conversation about policies. This is not a conversation about people. This is not a conversation about the shared value that we all have to keep kids safe. I think the role of the legislature in terms of oversight is to look at how are we spending state dollars, how are we rolling out policies that really support the safety of kids, and does it actually work the way that we intend it to? And sometimes there is that disconnection between the intention and the way that something rolls out. We're in a session where we have very difficult budget realities. We have a lot of decisions to make about where money goes. I'm personally very committed to looking under every rock to get more caseworkers, to get more screeners, to get more child protective services workers, and to get better training, because we know those people are working so hard at a job that is harder than I could ever possibly imagine, and the system can't be safe if we're not taking care of those people. But Senator Dembro?
Yeah, thanks, Madam Chair. If you'll indulge me, just,
yeah.
You know, one of the things that struck me in the presentations was, you know, reference to the multidisciplinary teams and having that team approach and the benefit of having that team approach, which I think we all agree to. And I'm just wondering, you know, is there a way to sort of meld that approach with a differential response kind of approach? I mean, is it, you know, one or the other, or, you know, is it possible to imagine an environment in which you had the MDTs, you know, working on this traditional cases, but also reviewing the alternative treatment or the alternative response cases, so that there was a kind of high level of confidence that everybody was being taken care of?
Well, I do not view the term differential response as the problem, because, as I said before, and as you said, voluntary services have always been offered. And if we think of it just as working with families to engage voluntarily, yes, we can be part of that. The threat for us is that it's a very different set of things that start happening immediately. There are no dispositions noted in differential response. So that's very different than the court system, where there are going to be dispositions. We think the value of having a dispositional finding is implicit. We oppose a system that shelters us from that by never calling it anything. So our attorneys that are working these cases, even though they're fewer, I'd like to side with the telephone caller, are finding that when those cases come into court, people are much more hostile because they've already been through months and months and months of differential response. They've tried to get out from under it and they haven't been successful, and they are now dug in. And that's another, that doesn't answer your question directly. I'd like to work, but it seems like under the present structure, it's institutionalized.
And the dispositional is the place where we look at an allegation and determine, is that founded or not founded?
Right.
That did it occur or did it not occur?
So
correct.
And it would be nice if there was a middle ground, and I don't know how you do this, but almost like a probationary with the court oversighting probationary status where it's not actually a full disposition, and engaging the families to work in a manner that has more eyes on it, and potentially taking an approach more like mental health with the WRAP team, where they actually put a group of service providers and those involved in the case wrapping around the family to help them and guide them through, and matching them with appropriate services and offering them encouragement, and really showing them that we're there to support versus being a punishment by being in front of the courts.
And this is just an editorial comment. Something that's always confused me about the way that we talk about things that happen to children. And when we talk about sexual violence and sexual assault, we urge survivors that they have not done anything wrong, and we name what that is. When we talk about domestic violence, we talk about not sugarcoating that violence or abuse has occurred, because we are working on empowering that victim, the person that has been harmed. In child abuse, it seems like we spend so much time working not to stigmatize the individual that has caused the harm to the child that we've built this whole system that says we're not going to call it what it is. And I just have to wonder what that means to a child who knows that people have come to look at them, who've come to ask them questions, and then we never say, no, it didn't happen, or yes, it did happen, and your parents are doing the best that they can, but also what happened to you isn't okay, and we need to help all of you. So I just wish that there was a way that we could balance all of those. It's not about stigmatizing families, but there's a point at which we wouldn't use this language in domestic violence work around adults. We would work on how do we create that plan of safety empowerment around that individual so that they don't feel like they have done something wrong in the process. But we really are losing the room. Thank you all very much, and I'm closing the information hearing on differential response, and we're adjourned.